RICO trial for former President Donald Trump. Trump's attorneys are trying to defend their client as he's been charged with all kinds of crimes related to, or alleged crimes, the election of 2020. They're trying to throw out that complaint based on First Amendment grounds. He and his alleged co-conspirators are looking at 41 combined charges for trying to overturn that election. Since his indictment in August, 4 of the co-defendants, including 3 of his former attorneys, have taken plea deals with the prosecution. They will be testifying in the trial against Trump. 15 defendants remain, including Trump, and those conversations are now being... It sounds almost like an appellate argument, the way counsel for former President Trump is laying out the case. But remember, there's no jury. This is a judge listening to this for issues of law, not fact. Let's go back in live.
Of restricting that speech as it relates to the elections. And the Constitution and the Supreme Court have said, we're going to put up with a heck of a lot of speech before we quiet it, because the result of telling somebody or prosecuting somebody for saying something about an election that a DA disagrees with is terribly, terribly dangerous in our society. And we're going to potentially shut down all of that speech with regard to dissonant or dissenting views we don't agree with. I'll get the word out.
If there's a dissenting opinion.
Dissenting, thank you.
The case is the kind of the window setting and
Yes.
or scene setting rather, and these broad principles you're referring to in these cases. Most of these, aren't they facial challenges where they're striking down a statute in its entirety that is solely and very obviously targeting speech?
Well, I think that that's right, but I think that you can attack the indictment here and the statutes under which it's charged upon just within the 4 corners of the complaint. Again, we're going to accept everything in there that they say is true, but even when we're accepting everything that they say in there is true, it doesn't reach up to these, and they are broad principles.
But just so I'm clear,
yes.
what lane we're in, though.
Yes.
The argument isn't like many of these cases that we read about and that establishes principles that the fraud statute
Right.
has to go away. It's as applied here. It's unconstitutional.
As applied here is unconstitutional. Yes.
We have to get over that first hurdle of whether we can make an as applied challenge, which I think that you've pointed out some case law we didn't consider the first go around. Right. And
I think that some of these statutes can be attacked facially, but yes, it's as applied here.
Okay. Well, maybe we should start there then. What statutes do you think we can attack facially?
I think that 1610-20 should be attacked facially.
Okay.
Haley makes that hard, but I think that it should be attacked facially. That probably is, the rest of them would be as applied. And then the next thing, Your Honor, again, kind of going, I'm sorry.
No, go ahead.
Oh. And once we decide that this is, I'm sorry. Once we decide that it is political speech, both the state and the legislature have a duty to do 2 things. They have to show that there is a compelling state interest with regard to what they are doing. And they also have to show that the restrictions on the speech are as narrowly possible.
That's what I'm getting held up on again, because that whole line of analysis, the legislature has nothing to do with this, right? Because the statute is what it is.
Right.
So in terms of whether it's been narrowly tailored or whatnot, if it's as applied, that's not really coming in, right?
No, you're right with regard to the attack on the statute, but what I'm getting at is the prosecution here. And the point being, with regard to all the statutes that are at issue and everything that they're prosecuting, is that as applied, none of them can stand because, and I'm about to get to this, because there is counter speech available. And the counter speech that's available, and that's discussed, a lot in Arneson. What the courts say is, listen, if you have debate and you have false speech, the Supreme Court has said, listen, the remedy for speech that is false is speech that is true. This is the ordinary course in a free society, and the response to the unreasoned is the rational, the uninformed, the enlightened, the straight out lie, the simple truth. And what happened in Arneson is that the court said, listen, if you say something false with regard to this ballot referendum, somebody else is going to pick up the ball and say something true. And you're going to have an invigorated debate about those issues, and that'll wash out in the election. What do we know about this case? Every single thing, every act, every count that's talked about in this case was published in real time and was very, very hotly contested. There was more than enough, a ton of counter speech. And what happened? What happened is the court challenges were resolved. Joe Biden was put into presidency in January of 2021, and we were done.
But I don't know if that legally makes a distinction, because if, as the state's theory as alleged had succeeded, you wouldn't then say here, I would presume that a prosecution is now greenlit under these same principles.
Under these same, I'm sorry.
If it's violating free speech regardless,
right,
it doesn't matter whether it was successful or not.
No,
right?
It doesn't matter whether it's successful. No, that's exactly right. All I'm saying is that part of the American experience is saying, listen, we're going to allow, it doesn't matter whether it's successful or not. Absolutely right. But what I'm saying is that the counter speech here that was available led to a result that apparently the state wants. And the counter to robust debate, court cases, and you got a result. And that is what the framers were trying to protect. That's what Arneson was trying to protect. That's what the United States Supreme Court is trying to protect in virtually every single case that they talk about. And I've noted here that when you look at the various cases, and I've cited a ton, these are a hand, I mean, you can cite Supreme Court cases and First Amendment cases all day long. But in all of these cases that the Supreme Court raises when it relates to political speech, it is almost invariably going to fall out on the side of let the speech occur. Even if it's false, even if it's fraudulent, when it's in the course of an election, and especially a presidential election, and especially when you're going to have people on the other side going at it hammer and tong to figure out what is the truth.
When you say even as with fraudulent, do you mean even if false?
Even if false, yes,
okay.
Excuse me. Even if false. And the Supreme Court has come again and again and again and said that this type of speech, we're going to protect it. And the state here in its indictment, the entire premise is, well, what you're saying is false. What you're saying is wrong. As of December the 3rd, when you have a result in the election, you ought to have known that Joe Biden was the winner. And because you said Joe Biden's not the winner, and because you filed a lawsuit and you had electors go and vote, and because you got on TV or did a tweet or came up with a legal theory, we want to put you in jail. That is anathema to our history, and it's anathema to the First Amendment. And I also cite cases here with regard to Georgia that are in accord. And, you know, Your Honor, before I kind of jump ahead, we talked a little bit about whether resolution is ripe. The Georgia Supreme Court, in a series of cases, have said that even if you have an as-applied challenge, you need to decide that case up front. Involves a First Amendment constitutional challenge, maybe not the same with other constitutional challenges. It also says that the court can consider a demurrer based solely on the state's averments And that's all we're asking here. We're not asking for anything else other than what's in the four corners of the complaint. And so taking all that, and I've truncated it quite a bit. But if you look at the cases, if you look at what's in the indictment, this isn't close. The defendant's statements and actions here are challenging the processes of the 2020 presidential election. It is political free speech. Once we know that it's political free speech, subject to strict scrutiny, the state tries to impose a viewpoint restriction on the defendants. You did not accept that Donald Trump won. And the entirety of the indictment is focused upon punishing defendants for that speech. And the state cannot show that the prosecution is narrowly tailored or that any of the statutes in the indictment are narrowly tailored, especially when you have counter speech here that is available. And the First Amendment absolutely precludes any of the state's claims here. And I think one thing that I wanted to, hold on one second. All right, got it. Is we are in the throes of this, right? I mean, it's hot, it's emotional, it is something that is topical. And we think this is the first time America has ever gone through this process. It's not. It just is not. I was down in Florida in 2000 for the recount of the Bush versus Gore election. That resulted in the Secretary of State. Remember the criticism she got, the Attorney General of Florida running around, decisions of the Florida Supreme Court, hotly contested. Is this ballot fraudulent? Is that counting fraudulent? It goes up to the United States Supreme Court. It lasts until almost January of 2001, about as long as this challenge lasts. And the Supreme Court, in a decision that a lot of people roundly criticize, say, this is the result. It's over. President Bush did not indict President Gore and his supporters for making those challenges. That was their political speech, and it resolved through the courts and through the political process as it should have. And when I was thinking about, when else did this happen again? What happened in Georgia? It's kind of a history buff type thing, but we probably have all heard that in 1946 or 47, you had the elected governor of Georgia die before he got into office. It's called the Three Governors controversy. And at that point in time, the Georgia General Assembly said his son, Herman Talmadge, we're going to make him governor. The duly elected lieutenant governor said, no, I get to be governor since I was duly elected as lieutenant governor. The sitting governor, Ellis Arnold, said, I'm going to hang around and I'm going to be governor. The Georgia Supreme Court weighed in, allegations of fraud, allegations of false statements, allegations that this just ain't right. And the Supreme Court said, well, it's going to be the lieutenant governor. But the members of the General Assembly that said it was Herman Talmadge, they didn't go to jail. Herman Talmadge didn't go to jail. Ellis Arnold didn't go to jail because they were advocating for a position that got worked out through the political process. In 1876, this is probably one of the craziest ones, Hayes versus Tilden. This led to the enactment of the ECA. Tilden was the popular winner. He was one vote shy in the electoral count, and Congress disallowed that one electoral vote from Oregon. They then didn't know who it was. At least according to the research I've done, this almost led to a second civil war. You have Congress put together a 15-member panel to figure out who's going to be the president, and it ultimately gets decided in a hotel room. Nobody went to jail. Very recently in Georgia history, the Kemp versus Abrams governor's election. Stacey Abrams said Brian Kemp didn't win. He illegitimately won. The election was based upon voter suppression. Numerous lawsuits won. She lost every one of those lawsuits. Stacey Abrams wasn't prosecuted, nor should she have been. Al Gore, Abrams, Kennedy, Tilden, Talmadge, members of the General Assembly, they are not prosecuted because what they were doing, even though they were pointing fingers back and forth saying, you're committing false statements, I'm the governor, you're the governor, I'm the president, no, you're the those came out in public and they were hotly contested, and the First Amendment protected all of that speech. But once we start punishing people for taking the positions and challenging elections, I've challenged lots of elections in 25 years of practice. I've been involved in tilting at a lot of windmills. Once we start saying that you are going to go to jail for doing that, those types of challenges are going to dry up. And that is
okay. So in this Fulton County courthouse, that is not, let me clear up some of the names of who's whom and where. Former President Donald Trump's attorneys are not arguing at this moment. This is for Robert Cheeley. He is a former attorney for Trump, who is one of the defendants in this case now against former President Trump. And his attorney is making that argument. We expected. It's a First Amendment argument. All these things that his client, Mr. Cheeley, said that were protected speech, politically protected speech, First Amendment kind of stuff. Big First Amendment fan. It saved my bacon many times. Katherine Lizardo is still here with me. She's from the Dallas-Fort Worth area. And joining us this hour is Fanon Rucker. He's a retired judge and a former prosecutor in Ohio. So let me start with you, Judge, because I want to get this perspective, slightly different from some of the others that we've chatted with about this case. This is a demurrer. This is an attack on the pleadings. This is not an analysis of the facts. The facts as they're pled are granted to be true, and therefore the court's looking at it to say as a matter of law, there is no case here. Give me your take on this maneuver.
Well, I don't know. It's one of those procedures that I think all of us in practice have attempted to exercise or have exercised. What people need to understand is that the demurrer, if it's granted, if it's agreed to by the court, that there is not a legal basis for the charge to proceed. All the prosecutor has to do is fix it and refile it. It doesn't ultimately end the case. It just says, well, as written, you can't proceed. So, it's great for hourly fees. It's great to stand before the court and make these arguments kind of as a preview to what's going to be argued once the case and the substance of the facts themselves are being raised. But ultimately, it's a fixable problem if it is granted.
Yeah, and that's a good point. That's a higher level analysis than the long crime in a classroom from earlier. The demurrer can be granted with leave to amend. And as you suggest, Judge, that means you go back to the drawing board, you change the pleadings. I've had them granted without leave to amend, and then you're done. That's a slam dunk. You're done. That case ain't coming back. Katherine, what have you heard so far? Again, this is the attorney for one of the co-defendants of Donald Trump, who was one of his attorneys. But it's going to be the same argument we're hearing for the president. What do you think?
I think, yes, we will hear the same arguments for the president by his lawyer. What I think, though, is the judge here is giving the defendant's attorneys hints as to what he needs to fully understand their argument for the demurrer. And he's saying, you got to tell me because I do not understand. And it's surprising the judge actually said that, because for me, you got to perk up and say, as a lawyer, he doesn't understand that. So that's where I should focus on. He said, I do not understand.
That is so helpful. You know, you don't often get that. And I think that's great. And this is Judge Scott McAfee. The other thing he said, Katherine, was, we didn't look at those cases before. So he's referring to his denial of the former demurrers filed by Kenneth Chesbrough and Sidney Powell before they took their plea deals. And he's now saying, I'm confronted with the same general arguments, but there are cases I wasn't presented with before. I got to look at those. I mean, to me, if you're presenting a case, whether it's on appeal or it's in this demurrer stage, man, you're getting excited, because that means you've at least got your foot in the door. Whether it's going to work or not, whether it's going to be slammed in your face, don't know. But at least you've got a judge that has admitted, that's something I haven't looked at, and we're gonna look at that.